versus Ever.
Good morning, members of the court, counsel. Donald Scott, Baker Donaldson, on behalf of the Bank of America National Association, who for the purpose of the day I'll refer to as BANA. May it please the court. We're here today on a post-foreclosure dispute between BANA and the association, which is the Enclave at Richmond Place Condominium Association in Hillsborough. I just want to briefly just run through several of the facts that are imported below because we'll be discussing them today. This stems from a foreclosure case, and the underlying note was issued to Bayrock Mortgage Company. Subsequently, the mortgage was assigned to Countrywide Home Loans, Inc. on 9/24/08. On the same day, a recorded assignment was from Countrywide Home Loans, Inc. to Federal National Mortgage Association, or Fannie Mae. Ultimately, the underlying note is endorsed a number of times, originally with Bayrock Mortgage Corp. To ultimately Countrywide Home Loans, Inc., endorsed in blank. The note goes into foreclosure. A complaint is filed on October 8th, 2008, with Countrywide Home Loans, Inc. being the plaintiff, and filing the note and moving forward. Ultimately, the association, who's named in the suit because of the safe harbor statute 718.116, they're a named defendant in the action, is to address any lien that they may have on the property. They answer on October 23rd of 2008, and then within that answer, they confess that the plaintiff is the first lien holder, and in fact that the safe harbor statute applies. The case goes on for several years, ultimately resulting in judgment in November of 2013. There is a sale in February of 2014, and a certificate of title issued to Bank of America National Association, who is the successor by merger to the original plaintiff, Countrywide Home Loans, Inc.
And that there was never an appeal of any of the judgment below or throughout any of the stage by the association?
Precisely, Your Honor. That's one of our first arguments that we made in the case, is that the trial court's altering of its original judgment was done so in violation of res judicata. The judgment and the certificate of title were issued and the time for an appeal lapsed. And subsequently, this dispute arose about the provisions of 718.116, and the plaintiff filed BANA filed a motion to enforce its original judgment. In response to that, the court allowed the association to basically relitigate the matters in its judgment, specifically holding that BANA was the first lien holder, and that its lien was superior to all others, including those, or except for those that are covered by 718.116.
And that was originally pled as an affirmative defense back in 2008?
It was, Your Honor.
And that was never amended, never changed?
Never amended, never changed. In fact, the association sat silently and did not litigate the point at all through judgment, through the certificate of title.
It didn't come up during the foreclosure trial?
It did not. And therefore, with the motion to enforce, which was post time for appeal, our argument is that the matter as to and the question as to BANA's position as first lien holder and the applicability of 718.116 was already adjudicated by the court, and that order was final and couldn't be appealed. And the trial court impermissibly altered that.
And what was the judge's thinking? What was the judge's reasoning in doing that?
Ultimately, within the trial court's order on that, he stated that that BANA was not the owner, and there was this ownership issue that arose over the note and the mortgage, which I intend to address later.
Yeah. Did he address that affirmative defense at that time?
Your Honor, I wasn't present at that hearing, so I do not have personal knowledge as to that particular fact.
I'll ask the appellee. All right, thank you.
So the first principal argument would be that the doctrine of res judicata prohibited the court from relitigating issues that were already decided. Secondly, it moves to a second point, which is equally cogent, which is that the point of judicial estoppel on the part of the association in this case. As we mentioned, they pled in their answer, whether it be an affirmative defense or otherwise, the fact that Weidner was the first lien holder and that by consequence 718.116 applied. And they allow that case to, that position to go to judgment without making any effort to litigate Weidner's position as the first lien holder, or even the applicability of 718.116, which it would have been completely appropriate to do. It's why the statute requires that they be named as a defendant in the original action. So the case goes to judgment. The time for appeal lapses, and then they want to subsequently take a wholly opposite position than that which they took in the earlier proceeding. And that is entirely the type of judicial flip-flopping that the judicial estoppel doctrine is designed to prevent. The Florida Supreme Court has spoken on that issue, and they did so. We have it within our briefs. They did so in a way that was a little bit unkind. It's saying that we don't want litigants to make a mockery of the judicial process by just flip-flopping their arguments just because it suits them later in a different proceeding. So we would also argue that the doctrine of judicial estoppel should prohibit the association from subsequently taking a position which is opposite to that in the original proceeding in which they were a party participant. Next, we move on to what is really the ultimate issue, and the source of the dispute in this case, or in this appeal. And it revolves around Weidner's position as the holder of the note and mortgage. And, 718.116 very clearly and explicitly provides that in Section 1G, that the first mortgagee is the holder of the note and the mortgage. And the association, within its arguments, but below and above, they make light of the assignment to Fannie Mae, and that's the last recorded assignment. But we know from case law, even in this district, that the mortgage is incident to the underlying debt. It follows in Everhome Mortgage Company versus Jensen, which is in this circuit. This court stated that if the note or other debt secured by the mortgage be transferred without any formal assignment of the mortgage in equity passes as an incident to the debt. And it's very important in this case that the underlying note was endorsed in blank. And we know that because it's endorsed in blank, it's the bearer who has all rights of enforcement of that underlying note. And when it pertains to the mortgage law, it's the party who has the rights to enforce the underlying note, consequently has the right to enforce the mortgage. And when you take 718.116 and it clearly provides that it is the holder who is entitled to safe harbor, we know from black letter foreclosure law that it is the holder that has standing, and it's the holder who is entitled to safe harbor. This business about ownership of the loan documents is wholly and entirely irrelevant. This court, in addressing it in the context of standing to foreclose, which is basically the same positions we have with 718.116, Judge Kelly, Your Honor, wrote in One West Bank versus Bauer that because One West Bank possessed the original note endorsed in blank, it was the lawful holder of the note entitled to enforce its terms. In requiring One West Bank to prove ownership of the loan documents to establish its standing to foreclose, we conclude that the trial court departed from the essential requirements of law by imposing a condition which does not exist. We know that that's the law of foreclosure as it relates to standing. And because the Safe Harbor statute at 718.116 uses the very same terminology, holder, we know that that same logic must apply. Ownership of the note is irrelevant. There is no body of law. There are no statutes. There is nothing that requires ownership, however that term might be defined, to apply to the Safe Harbor statute, because the patent terms of the statute itself only refers to the holder. Are there any questions I can take on that issue? Okay, decided to reserve the balance of my time.
Okay, thank you.
Members of the court, counsel, may it please the court. My name's Scott Davis. I represent the Condominium Association here today, the Enclave at Richmond. There's a few issues there's actually more issues at play than was just argued. There was a jurisdictional issue which has been briefed. I'll get to that. Then there was the issue of the ownership. Does ownership of the note and mortgage matter, or can a servicer, somebody who has no beneficial interest in the note and mortgage, foreclose and take title? And would that comport with the public policy behind giving lenders, people who put money out on the street, a limitation liability? So those are the two, in broad terms, those are the two issues, two main issues anyway. Counsel pointed out or made an argument that the issue was decided below when the mortgage foreclosure judgment was entered, and that the judgment decided that safe harbor applied. If you look at the judgment, that's actually not the case. Paragraphs 5 and 10 of the judgment point out that the plaintiff's lien is superior except for assessment claims under 718 or 720, which is the companion homeowners.
But didn't the association plead in its affirmative defense that the BOA lien was superior to the association lien? I mean, wasn't that the long-standing pleading?
That was, yes, Your Honor, they did.
And that was never amended, so why aren't you stopped at this point from being bound by that?
Going to the judicial estoppel issue, the fact is, the association, and this prior counsel filed that answer, but the association actually did deny in its response to paragraph 10. It was an allegation that the bank's lien was superior to the association's, and they denied that. That's in the body of the answer itself. The affirmative defense, if you look at its wording, it's almost, I don't know why you would put it in there. It's a nullity. It basically says that this is, we recognize this is a first mortgage, and in fact, we did not challenge standing, because they did have in their possession the note endorsed in blank. So we didn't challenge standing below. We don't challenge standing now. Our point is that it takes more than being the person who has standing in the mortgage foreclosure case to be entitled to the safe harbor. It's a smaller class of individuals that qualify.
But your pleading specifically referenced the safe harbor statute.
Yes. It says, well, again,
it says that pursuant to Florida Statute 718.116, the plaintiff's lien is superior to any title and any interest to any condominium assessments except for those unpaid dues, and then it quotes the language of the statute.
Right.
I'm just struggling to figure out, then the case goes to trial, it goes to foreclosure, it goes to final judgment on that state of the pleadings. So why isn't that end the matter from insofar as the priority of the lien?
Well, I would argue, first off, that's really truly not an affirmative defense. It's surplusage. It could and should have been stricken. Secondly, the fact that we denied in the body of the answer.
So you would refer me to paragraph 10 of your answer?
Yes, Your Honor.
Okay.
You'd probably have to look at the mortgage foreclosure complaint. I mean, that's where they alleged their lien was superior. That was denied. Turning back for a minute to the jurisdictional issue, and this was brief. Counsel didn't address it, but In very similar, if not exactly the same circumstances in the Central Mortgage versus Callahan case, which came out in March of last year, actually July of last year, 2014. And that came out after we had the hearing on this. But we did raise lack of jurisdiction in our papers below as in opposition.
Is it your position today that the court lacked jurisdiction to entertain the enforcement?
Yes, Your Honor. I mean, we did win it, but Callahan came out after, prior to Callahan, it was debatable.
Because you initially objected to jurisdiction, and the court determined that in fact it had jurisdiction, then nobody appealed that decision because you ended up winning your argument. So at that point, I suppose you said, well, we'll abandon the if you want to exercise jurisdiction and hand us the victory, we're okay with that.
Well, I suppose, yes. I mean, we weren't going to appeal at that point, but now that it's been appealed.
Well, it hasn't been appealed.
Well, it's I guess the issue is raised in the sense that if it goes to the subject matter jurisdiction, which the Callahan decision says it does, and then following up the Callahan decision was the Montreux decision, which are in the briefs. They both say because the trial court did not specifically reserve jurisdiction, and more importantly, because those decisions state that because the trial court did not make a finding as to whether safe harbor applied or not. The language was the same. It's the uniform judgment. It just said it may apply or it may not. You're superior to the extent that you are entitled to being superior under these statutes. And so the Callahan case and the Montreux case stand for the proposition that because that issue was never decided below, you cannot come back now after the time for an appeal has expired or after a time for a 1.530 motion has passed and come back into the original case and file not even a pleading, but a motion asking to reopen it. And in order to invoke the subject matter jurisdiction to enforce, the bank says, we're trying to enforce this judgment. That's all it is. Well, in fact, their motion asked for the court to determine the amounts that were owed, which is something that obviously was not determined in the case below. So Callahan and Montreux said, you can't go back in and reopen a case. The court lacks subject matter jurisdiction. You can file another deck action or something of that nature. But the trial court doesn't have jurisdiction to do that. And that's what happened here. And of course, subject matter jurisdiction is broadly considered does this court have the authority to rule on this type of case? And generally speaking, yes, circuit court can rule on mortgage foreclosures. But the other prong of it is that the subject matter jurisdiction is only potential until one of the parties invokes it through the filing of a proper pleading. And there's some case law on that as well. Because let's say I'm having a dispute with my neighbor and we go to arbitration and my other neighbor who's a judge says, you know what, I'll just resolve this for you guys and enters an order. Well, none of us filed a pleading with the court, so we didn't invoke the jurisdiction. So you have two cases, Central Mortgage v. Callahan and Montreux, that are factually almost indistinguishable. These were post-judgment assessment disputes over safe harbor. The proper course of action would have been to file a deck action, which most of the time is what is being done now. In fact, I don't know any of the bank's lawyers that are going back into these cases after Callahan.
The problem is you didn't cross appeal that. So how's that in front of us?
Well, Your Honor, if it's subject matter jurisdiction, then it's not waivable. It can be raised for the first time on appeal. And we in fact,
but you didn't raise it.
Well,
I mean, that's the problem. You didn't raise it.
It can be raised for the first time on appeal, though there's
actually... Okay, I understand that, but you have not raised it on appeal by filing a cross appeal.
Okay. There's another case that I would direct Your Honor to that I think answers your question, and this is a second district case. It's 84 Lumber versus Cooper, 1994 case. In second district, in that case involved an injured employee of 84 Lumber. He sued the tortfeasor. They settled. The employer had a right of subrogation under the health plan. The employer filed a motion to reopen the case after it had been dismissed, and the court then adjudicated their reimbursement claim and gave the employer a lot less money than they were looking for, so they appealed it. Then, on appeal, the second district said it's our obligation to look at whether there was subject matter jurisdiction. And even though, on appeal, the employer was saying there's no subject matter jurisdiction, even though below they had said, here it is, Judge, decide this for us. And the court said, you know, just because the parties agree, mistakenly or by stipulation that there is jurisdiction. That is not permitted. We have to look at it, and if we think that there's not subject matter jurisdiction, then that's the end of it. Then the order below is void. Now, there are jurisdictional issues that are waivable. For example, personal jurisdiction. If I can't raise that at any point in the proceedings if I appear and file an answer or something like that. But when you go to the subject matter jurisdiction, then that is something that not only can be raised at any time, but the courts, at least according to 84 Lumber, they say that the courts have an obligation to look and make sure they actually have subject matter jurisdiction. So
Whose jurisdiction was the second district looking at? Its jurisdiction or the trial court's jurisdiction?
the trial court's jurisdiction.
And no party raised it in that appeal?
If I recall correctly, the opinion was sort of ironic. It said, it's interesting that 84 Lumber comes to us now and says the trial court didn't have jurisdiction because they didn't get the result.
So it sounds like somebody raised it on appeal.
I don't know if it was in the briefs or if the appellate court just recognized it. I don't recall.
Well, I mean, a court always has jurisdiction to consider its own jurisdiction.
Correct.
But the position you're taking is that we can examine the trial court's jurisdiction as a potential error on appeal, even though no parties raised it.
Yes, because...
And you say that 84 Lumber supports that proposition.
Yes.
Do you have anything else to cite to for that?
Well, just the general jurisprudence that says that a order or a judgment that's entered without jurisdiction is void. I mean, I guess we could file a lawsuit 2 years from now and say this is a void judgment and give us relief because there was never proper subject matter jurisdiction. Even if we never raised it on appeal, it may, if it's decided that there was jurisdiction, the way I understand the case law is that you could file a separate action seeking relief under Rule 1.540 because the judgment was void.
So if for some reason we decided, and I don't know that we can, but if we did, that the trial court did not have jurisdiction and should not have entered this award, is there any bar to your client at this point filing its own separate action, even after all this time has gone by, that you're aware of?
There is actually a separate action that's been stayed, Your Honor.
There is another one.
There's a lien foreclosure. We filed a lien foreclosure action which has been stayed pending appeal.
I see.
And these issues could, of course, could and should be decided in that case. If that case goes forward, I mean, it depends on the outcome of this case, obviously. But I can answer more questions on jurisdiction. If there are no more questions on jurisdiction, I'd like to move into the ownership issue of the note. We cite cases in our briefs, the Bermuda Dunes case and the Beltway Capital case, which stand for the proposition that the party that gets the safe harbor is the one that has the rights and obligations under the loan at the time of the foreclosure. The Beltway Capital case actually cited to a case called Oriole, cited to a case called Oriole. I don't have the citation right in front of me. And in the Oriole case, that was a federal case out of the Southern District where a servicer had brought up a foreclosure action and had assigned the bid to Fannie Mae, and Fannie Mae purchased the property. And the Condo Association said, "Well, wait a second. You're a third-party purchaser. You weren't the holder of the note." And the judge, in his opinion, says that the plaintiffs or the plaintiffs' counsel, the association counsel, didn't understand the nature of the way this works. That is, Fannie is the owner, and there was no evidence that Fannie was never the owner at all times material. And as such, Fannie was entitled to the safe harbor. It didn't matter that the action was prosecuted and a judgment was entered in the name of the servicing agent. And that's what we have, essentially what we have here is the mortgage foreclosure complaint alleged in paragraph 3 that the bank was not the owner. It was bringing the action as the servicer. And they actually attached to the complaint a copy of the last assignment showing that Fannie Mae owns it. That assignment assigned not only the mortgage but also the note. So the evidence was that, okay, servicing agent, that's fine. There's a lot of case law that says MERS and other servicers can bring these suits on behalf of the owner of the note. And in those situations, many times, Fannie Mae will come out and say, well, we were the beneficial owner, sometimes the undisclosed owner, and we're entitled to safe harbor if they took an assignment of the bid. In this case, the fact that Bank of America ultimately was the in possession of the note assigned in blank doesn't square with the fact that Fannie Mae was the owner, and as the owner, there's case law that says you can have constructive delivery of the note. So if I buy the note from you, but you don't give it to me, it's considered to be constructively delivered to me, and I can enforce that. There's some case law on that as well, some of which I think is cited in, one of the cases was cited in the association's brief. This is the MERS versus Reveredo, constructive delivery of the note. So what happens here in these situations is Fannie usually does not prosecute the cases. They have servicers that do it. They own the note. They hire a law firm to go out and prosecute the action. Well, actually, the servicer does. So the note documents, the loan documents are transferred to the servicer so that they can prosecute the foreclosure. And they have to hire a law firm, and so they do have to have actual physical possession of the note to file it with the court. But that doesn't make them the owner, as described in Bermuda Dunes and Beltway Capital, to qualify for safe harbor. And there's a policy reason behind that, and that is, you know, the safe harbor is there to encourage lending, to encourage banks to put money at risk for condos. Servicers they don't have any skin in the game, so to speak. They didn't make the loan. So they don't have a beneficial interest in the note mortgage. So I would respectfully suggest that in this case, this is just like the Oriole case that was cited in Beltway Capital, where Fannie claims, in that case, that they were the owner all along. Now, B of A, who filed the prior counsel in the foreclosure case, actually prepared the assignment to Fannie Mae. Bank of America has not alleged in its papers or in its argument that they were the beneficial owner, or that assignment of mortgage did not convey beneficial ownership to Fannie. So that's pretty much it, Your Honor. If there's any questions, I'll be happy to answer them. If not, I'm done. Thank you.
Thank you.
Your Honors, if I may very quickly address the jurisdictional issue. Florida Supreme Court has long held that trial courts retain jurisdiction to enforce their judgments, even if that is not expressly reserved. That's precisely the kind of thing we had here. Boehner does not dispute that the trial court had jurisdiction to entertain the motion. I think that's probably, as well as Boehner also thinks, that that's the most efficient way to deal with this issue. The whole thing arises by this whole estoppel argument, which we've also made, that what the associations are doing, they're named in the lawsuit, they're named in the foreclosure, they're named for a reason. They're placed there because they're required to by 718-116. And what they did, which is what they did here, is they just laid the weeds for the entirety of the litigation, wait until judgment is issued and title is dispersed, and then, for the first time, take a position that the plaintiff, in this case Boehner, was not the lien holder and not entitled to safe harbor under 718-116. That is a matter which should have been litigated below in the original foreclosure case, but they chose or elected not to do it, and they waived it. And to buy into this argument that somehow certificate of title can issue, and then subsequently a new lawsuit is required to determine the applicability of 718-116, it condemns the courts of Florida to having two foreclosure cases in almost every foreclosure case. You're going to have one that involves the foreclosure of the noted and the borrower, and then subsequently you're going to have a dispute between whoever takes title and the association over the applicability of safe harbor. It's wasteful, it's unnecessary, it's against the interest of judicial economy. Even though it was not made a point of error by any of the parties in this case, Boehner did brief the position that the trial court correctly had jurisdiction to enforce its own judgment, which was against the association as a defendant, and that therefore its decision there was proper. There is as counsel pointed out, differing authority in the 3rd District from Callahan. We briefed the issue so that the court, if it felt so inclined to address the propriety of that mechanism for this safe harbor issue. Turning back to counsel's remarks about ownership and servicing are wholly irrelevant. Ownership is not discussed anywhere in the statute. 718.116 very plainly states holder, and we know what the holder is. The 5th District, in dealing with Bermuda Dunes and Beltway, neither of those decisions explicitly take the position that only the owner is entitled to safe harbor. Bermuda Dunes dealt with really a situation where the plaintiff was not the ultimate party who took title, which is not analogous to this case at all. And Beltway dealt with an issue basically defining who the first mortgagee was as it relates to time, not as to position. And it is an undisputed fact in this case that Boehner is the first lien holder in position. And they are the holder of the note, and that is all that is required. As far as the assignment, there is this assignment out there to Fannie Mae, and it stops there. But, as I pointed out in this court's own decision in Bauer, ownership, as that term is used, is wholly irrelevant in the issue in standing. It is completely unnecessary to prove, and it frustrates the purpose. What we have here is, as far as Fannie owning the note and perhaps Boehner being a servicer, that argument's irrelevant. What is relevant is that Boehner is the holder, and it's pled in the complaint that they're the holder, and it goes through the entirety of the litigation that they're the holder, and they take title as the holder. And the UCC very plainly defines what that term is. And that was codified by Florida statute, and it's the law of this state. There is no case law that counsel can point to, or any association that says an owner is entitled to safe harbor and no one else. The statute itself says holder. And we would request that this court reverse the trial court on that position and state that, instructing the trial court that Boehner is the first lien holder. They're the holder of the note and the mortgage, as that term is applicable to 718.116, and that safe harbor is appropriate and required for all past due assessments.
Thank you.
Are there any questions? Thank you.
Thank you.